Good morning, everyone. Today I'll be talking about tackling sexual harassment in the workplace. Over the last year, sexual harassment has frequently been in the news as a result of scandals concerning some well-known Hollywood faces and even our own politicians. Earlier this week, an independent inquiry established bullying and sexual harassment were not being dealt with in the House of Commons due to a culture of acquiescence and silence. The inquiry has even led to calls for the Speaker's resignation. These scandals have shone a spotlight on the issue of sexual harassment in the workplace and what, if anything, has actually been achieved over the last 40 years since legislation was first introduced to tackle the issue. A recent survey of 3,000 workers undertaken by the BBC found that 40% of women and 18% of men have suffered some form of sexual harassment at work. The common perpetrators in those cases were senior colleagues, and nearly a quarter of victims reported being harassed by clients, customers, and service users. Some even reported suffering harassment during the recruitment process. What such surveys and inquiries have uncovered is that there is a real problem of sexual harassment going unreported. Mainly this is because of a culture of fear being instilled in the organisations, that careers will be stunted or complaints simply brushed aside should they be raised. The real issue, therefore, appears to be one of cultural change, and that this must be driven by the leadership team. In this session, I'll be touching on how organisations can tackle this problem. In addition, I'll revisit what actually constitutes sexual harassment in the workplace and the forms it can take. I'll look at some of the recommendations made by the Women and Equalities Committee in their recent report on tackling sexual harassment at work, and I'll be looking at the consequences of not doing anything to address the issue.
We're right at the beginning, so we're okay. Let's start again.
Yeah, I just realised that we should have gone on to that slide.
No worries, that's fine. So cancel.
Good morning, everyone. In this session, I'll be looking at tackling sexual harassment in the workplace. Over the last year, sexual harassment has frequently been in the news as a result of scandals concerning some well-known Hollywood faces, and even our own politicians. On Monday, an independent inquiry established bullying and sexual harassment were not being dealt with in the House of Commons due to a culture of acquiescence and silence. The inquiry has even led to calls for the Speaker's resignation. These scandals have shone a spotlight on the issue of sexual harassment in the workplace and what, if anything, has actually been achieved over the last 40 years since legislation was first introduced to tackle the issue. A recent survey of 3,000 workers undertaken by the BBC found that 40% of women and 18% of men have suffered some form of sexual harassment at work. The common perpetrators in those cases were senior colleagues, and nearly a quarter of victims reported being harassed by clients, customers, and service users. Some even reported suffering harassment during the recruitment process. What such surveys and inquiries have uncovered is that there is a real problem of sexual harassment going unreported. Mainly, this is due to a culture of fear being instilled in the organisations, that careers will be stunted or complaints simply brushed aside should they be raised. The real issue, therefore, appears to be one of cultural change, and that this must be driven by the leadership team. Today we'll be touching on how organisations can tackle this problem. In addition, we'll revisit what actually constitutes sexual harassment in the workplace and the forms it can take. I'll look at some of the recommendations made by the Women and Equalities Committee in their recent report on tackling sexual harassment at work and the impact of not doing anything to address the issue. So, let's look at the legal definition of sexual harassment as set out under Section 26 of the Equality Act. Sexual harassment is any unwanted conduct of a sexual nature which is intended to or has the effect of violating a person's dignity or creating an intimidating, humiliating, hostile, degrading or offensive environment for them. Forms that sexual harassment can take include physical contact, comments of a sexual nature, or sending sexually explicit emails and images. These are just examples. A one-off incident is enough to amount to sexual harassment under the Equality Act. Whether conduct amounts to sexual harassment depends on the perception of the victim, the circumstances of the case, and whether it was reasonable for the conduct to have that effect on the victim. Those of you who are avid Celebrity Big Brother fans will have seen how these factors apply in practice. As you may be aware, this year there was an incident where a celebrity contestant perceived she had been assaulted by a fellow celebrity in the house when he playfully punched her in the ribs. However, the incident was caught on camera, and those watching at home overwhelmingly felt that she had overreacted in the circumstances. After her exit, she later reviewed the footage of the incident, acknowledged this, and agreed it was not reasonable for her to have made the allegation. So who is protected from sexual harassment at work? Well, job applicants, workers, agency workers, and employees will be protected from sexual harassment under the Equality Act. Also, secondees and former employees will be protected. Self-employed consultants could be covered by the Equality Act, but even if not, they could bring a civil claim of sexual harassment as a service provider under the Equality Act or the Protection from Harassment Act 1997. So, most of your workforce will be protected from sexual harassment throughout the whole of the employment life cycle and even afterwards. I now just want to touch on a few key concepts concerning sexual harassment. The first of those is where employers can be held liable for their workers' actions. Under English law, we have the concept of vicarious liability. In the employment context, vicarious liability is where an employer can be held accountable for the acts of its staff, unless it has taken reasonable steps to prevent the employee from carrying out the act. The Equality Act has a specific provision in which it goes a little further than vicarious liability. Under the Act, an employer will be held liable for a worker's actions done in the course of their employment, whether or not the act was done with the employer's knowledge or approval. Again, though, the same defence will apply. This means that if a member of staff sexually harasses a colleague, customer, supplier, or someone they come into contact with as part of their employment, your organisation could be deemed liable. There is significant case law concerning what counts as being done in the course of employment. Clearly, employment-related decisions made by management and a work colleague's inappropriate conduct in the workplace will. But the lines get a little blurred when the sexual harassment takes place outside of normal working hours or off the premises. In those cases, relevant factors which will point towards the act being done in the course of employment are the incident taking place on the employer's premises, the victim or discriminator being on duty, the gathering only including the employees, their partners or customers, as opposed to unrelated third parties, and the event taking place immediately after work. If the conduct was committed in the course of employment, the employer does have a defence if it can show that it took all reasonable steps to prevent the worker from carrying out the act. Such steps will usually include having and implementing an anti-harassment policy, making staff aware of the policy, providing regular training for all staff, training managers and supervisors on harassment, and effective complaint management. However, in light of the findings of recent inquiries into sexual harassment, I suspect the Employment Tribunal will soon require a greater degree of effort from the employer's senior leadership team to establish that defence. The next concept I wanted to touch on briefly is third-party harassment. This is where a member of staff is harassed by a customer or visitor whilst working. This is particularly an issue in the hospitality industry. Take, for example, the Financial Times expose on the President's Club's charity dinners, where hostesses were required to wear provocative clothing, were allegedly groped by guests, and were required to sign a prohibitive non-disclosure agreement on recruitment, silencing them from discussing anything that went on at the event. When the Equality Act was first introduced, employers could be held liable if they did not take reasonable steps to prevent third-party harassment, if they were aware the member of staff had previously suffered harassment at work. However, that provision was removed in 2013. Arguably, though, an employee could claim that any inaction by the employer could amount to an act of harassment under the Equality Act, particularly if the employer has some control but takes no action to prevent the harassment from reoccurring. Finally, I just wanted to touch on the concept of associative harassment. This is where an employee claims they have suffered harassment because of their association with the victim. For example, if an employee overheard a colleague being subjected to sexist jokes, and that caused an offensive environment for them. So as you can see, there are various aspects of the working environment which create a real risk of workers being subjected to sexual harassment. As I mentioned at the beginning of this session, the sexual harassment scandals playing out in the media have raised questions about whether the problem has ever really gone away. In the wake of such scandals, several reports were commissioned by parliamentary committees and regulatory bodies. The most notable of those was the report published by the Women and Equalities Committee on the 25th of July 2018. The committee's findings were that the workplace was rife with sexual harassment and that the government should prioritise the issue and require employers and regulators to do much more to tackle it. The committee made several recommendations to the government, the main ones being introducing a statutory code of practice which employers should follow to protect staff from harassment and victimisation, with a 25% uplift in compensation for breaches, as in the case for disciplinary and grievance procedures, making the employer pay a victim's legal costs if sexual harassment is proven at an employment tribunal, introducing financial penalties linked to turnover, such as those that have been introduced in relation to protecting personal data and anti-money laundering, the justification being that protecting employee safety and dignity is just as important. Requiring regulators, such as the Health and Safety Executive, to take a more active role in enforcement, for example, giving them the power to issue guidance, undertake specific risk assessments, and investigate reports of particularly poor practice. Introducing a mandatory requirement to report breaches to the regulator, which are taken into account when considering the fitness and propriety of regulatory individuals and their employers. And finally, curbing abuse of confidentiality clauses in settlement agreements and non-disclosure agreements. Some of you may have read about an alleged victim of a Hollywood mogul who entered into a settlement agreement with him which contained significant provisions silencing her from mentioning anything about the alleged incident and prohibiting her from having a copy of the settlement agreement. One can certainly see a new statutory code being introduced and perhaps more being required of regulators to tackle the problem, but it is doubtful that financial penalties of the like we see with data protection will be introduced anytime soon. Establishing when an employer has fallen below the required standard to impose a penalty will need to be governed by a regulatory body, which would need to be sufficiently resourced to carry out the necessary investigations, deal with complaints, and impose enforcement action. However, that doesn't mean employers should not be taking steps now to tackle the issue, as there are already many consequences of not doing so. So before we look at what those consequences might be, what should employers be doing now to tackle sexual harassment at work? Well, first of all, do you as an organisation make all staff aware of what is unacceptable conduct in the workplace and who they can talk to if they have a complaint through the use of equality and diversity, anti-harassment policies and whistleblowing policies? If not, now is the time to introduce them. If you already have such policies in place, have they been recently reviewed? If not, now is a good time to do so to ensure that they are fit for purpose, they are easily accessible, they are easy to follow, and they direct the complainant to the right person. Do you check that all staff have read the policy and understand it? Have staff received regular and comprehensive training to reinforce the contents of the policy? Do those persons responsible for dealing with complaints receive the appropriate training to deal with complaints in confidence and independently? Do the senior leadership team also receive focused training? And is the training rolled out to new starters and on an annual basis? Now, those have always been the recognised steps to take to address harassment of any kind at work. However, the recent inquiries all established that this is not enough to tackle the problem. The consistent finding in all of the inquiries published to date is that most incidents go unreported because victims lack confidence their complaint will be dealt with independently and or they believe it would harm their career prospects, mainly due to most complaints concerning the senior leadership team. As a result, despite there being up-to-date policies and training in place, the problem doesn't get addressed and often goes on undetected. So, how can you be confident your organisation doesn't have a hidden problem? Well, undertaking an independent review may give you the answers. The purpose of the review could be to establish whether there is a history of sexual harassment complaints, whether they were independently investigated promptly and fairly, whether the investigator was specially trained, whether the conclusions drawn were reasonable, whether complaints derived from certain areas of the organisation, whether there are multiple complaints against the same perpetrator, whether those who raised complaints felt supported when doing so and confident they would be heard, whether they believed their complaints were independently looked into, whether there were support mechanisms for the alleged perpetrator, and whether the victims felt protected from retaliation. By anonymising the investigation and/or using external independent specialists, staff will feel encouraged to share their experiences of bullying and sexual harassment. Upon carrying out a review of this nature, an action plan should be drawn up to address the problems identified. An approach the Old Vic Theatre has taken following an independent investigation into complaints of sexual abuse was to appoint specially trained guardians who are available to talk confidentially with colleagues, thus giving staff the confidence to speak up and feel as though their complaint was not being brushed off. It also meant senior management could get valuable feedback from the guardians on the types of workplace issues being raised, which may otherwise have gone unreported or unnoticed. Other steps to consider taking will include undertaking a risk assessment to identify areas within the organisation which are prone to sexual harassment, and a review of template settlement agreements and non-disclosure agreements to ensure they do not prohibit a whistleblowing disclosure or go further than reasonably necessary to maintain the confidentiality of the reasons for the employee's exit. Now, if sexual harassment is not tackled in the workplace, but is instead tolerated, there are several significant consequences for an organisation. The first of those is the risk of employment tribunal claims increasing, and with that, the cost incurred by the organisation through costly settlements and legal fees. However, there are also indirect financial consequences. The organisation's reputation risks being tarnished, which is crucial if it has a brand image to maintain. This can affect customer confidence in the brand and contractual agreements with suppliers or clients who may wish to disassociate themselves from the brand. And a damaged reputation may also harm employee engagement and retention, and possibly lead to the organisation missing out on key talent who are put off by allegations of misconduct and mistreatment of staff. The harsh reality for some organisations is that to truly tackle the issue of sexual harassment, a change in workplace culture may be required. And the starting point for that change is likely to come from the top. Many thanks for your attention.